Good morning, everybody. This is Amanda Nara, your instructor, and I'm going to record nursing practice and the law today. So it's your legal issues lecture. So objectives for this lecture include we'll analyze the importance of providing nursing care according to established standards of care. We're going to look at the legal scope of nursing practice. We'll discuss roles and responsibilities, what the State Board of Nursing does, and the National Council of State Boards of Nursing. We'll evaluate the role of the Board of Nursing to enforce the rules and regulations regarding professional conduct. We'll also illustrate performance guidelines for nursing students, identify key aspects of licensing and credentialing. We'll look into how the Nurse Practice Act guides our nursing care. We'll explain licensure, analyze components that impact licensure, and then interpret how the Nurse Licensure Compact benefits nurses. So, what is law? Law refers to any system of regulations that govern the conduct of individuals within a community and/or society in response to the need for regularity, consistency, and justice. Law also is the rules that prescribe and control social conduct in a formal and legally binding manner. So there's three different types of laws. We have statutory law, common law, and administrative law. So statutory law is created by various legislative bodies, such as your state legislators or Congress. Some examples of federal statutes include the Patients' Health Determination Act of 1990. We have the Americans with Disabilities Act. We also have the Affordable Care Act. And then some examples of state statutes include the Nurse Practice Acts or Good Samaritan laws. Laws that govern nursing practice fall under the category of statutory law. Hint, hint, you might want to remember that. Common law comes from the traditional unwritten law of England. It's been around for centuries, developed within the court system as judicial decisions are made, and then one decision typically creates the precedents for another. Administrative law involves procedures such as rules, regulations, and licenses. They're created by administrative agencies such as city councils, county boards, state government. They also can be established through the authority given to government agencies by a legislative body. This includes our State Board of Nursing. Some other sources of law, we have the Constitution, which we all should be familiar with, the foundation of our American law. There's the Bill of Rights. The Constitution limits the power of the government, protects citizens' freedoms. It also has constitutional law that evolves as issues emerge. We all know that it's ever changing. So there's statutes as well, which is more for localities, state legislators, and U.S. Congress. They also create statutes. There's city ordinance, local statutes. Examples would be like a noise ordinance. And then nurses also can influence the development of statutory laws. There's administrative law, which is created by administrative agencies that develop specific rules and regulations that direct the implementation of statutory law. Excuse me. So rules must be consistent with statutory laws. Specific statutory laws give state boards of nursing the authority to issue and revoke licenses. Some agencies you probably have already heard of: Department of Health and Human Services, the Department of Labor, and the Department of Education. So what are some laws relevant to nursing practice? Well, criminal law. So criminal laws are in place to protect society from actions that threaten its existence. So probably familiar with the felonies, the most serious of criminal laws. You think about murder, homicide, grand larceny, and it can also be a Nurse Practice Act violation. Then you have misdemeanors, which usually are lesser offenses like traffic violations. And then with juvenile crimes, you have those carried out by individuals younger than 18 years, and it is a specific age varies typically by state and then what crime they do. So acts that are criminal for any nursing professional include drug diversion and distribution, as well as falsification of records. So there's a great example on page 37 of your book of how serious falsification of records can be. This case involved a nurse who administered a blood transfusion, and she ended up failing to properly check all of the paperwork and follow the standards of practice prior to administering it. And then the patient, unfortunately, received incompatible blood and ended up suffering a transfusion reaction and died. So what the nurse did, she intentionally attempted to hide what she did. She falsified her record. She threw away all of the blood products and equipment and any evidence, did not notify the patient's doctor of the error, and the jury ended up finding her guilty of simple manslaughter and sentenced her to 5 years in prison. So somehow must have been within their investigation that they found that she committed this crime. All right, moving on, let's go to civil law. So civil law involves the violation of one person's right by another. So there's several different civil laws. There's tort, which is a legal or civil wrong carried out by one person against another person or their property. So in our case, nurses have a duty to deliver care in such a manner that the consumers of care are not harmed. So these are legal duties of care that may be violated intentionally or unintentionally. And then we also have quasi-intentional torts, which are voluntary acts that directly cause an anguish, injury, without meaning to harm or to cause distress. So the elements of cause and desire are present, but the element of intent is missing. Usually involves problems in communication that result in damage to a person's reputation, violation of personal privacy, or infringement of an individual's civil rights. These include defamation of character, and then you have invasion of privacy and breach of confidentiality. So there's some samples listed there, page 41. There's a sample of several nurses. Both of those look at defamation of character and invasion of privacy. So several nurses is page 41 for defamation of character, and then several nursing students is another one of invasion of privacy, and then breach of confidentiality is Evan on page 39. Please read those examples. And then we'll look into negligence and malpractice, which might be the most common areas of legal issues in nursing and the medical field in general. So we look at negligence. It's typically unintentional. So it can include failing to follow standards of care. So ask yourself, would any reasonable, prudent practitioner with similar education experience do or not do the exact same action in a similar circumstance? So you're also, when determining whether or not negligence occurred, you want to follow the elements that must be present. So there's 4 of them. There's duty, breach of duty, causation, and harm or injury. So examples of negligence from the book include a nurse administers the wrong medication to the patient, but the patient is not injured. Did any harm occur? No, then the element of harm is not met and negligence cannot be determined. However, if a nurse administers the right medication but fails to put up the side rails of the bed and then the patient falls and breaks a hip, then all 4 elements have been met. It was an unintentional outcome where injury and negligence occurred. So malpractice, we know, is professional negligence when fulfillment of duties requires specialized education. That term, malpractice, is used. So employers are liable for negligence by employees, and malpractice is more serious and is often improper or unethical conduct or unreasonable lack of skill. Okay, so let's move on to some other laws. So Good Samaritan laws, they were created to encourage physicians and nurses to respond to emergencies, and it protects licensed healthcare providers from civil liability as long as they behave in the same manner as an ordinary, reasonable, prudent professional in the same or similar circumstances. So standards of care must be upheld in the emergency situation, and no payments can be received. Otherwise, if, say, a doctor responded to an emergency and they ended up being paid for that service, then the Good Samaritan laws wouldn't apply. Confidentiality. So, of course, patients have the right to confidentiality. We know that information should only be shared with others who have a need to know basis. Um, you need permission to share information. You need the patients to complete a medical records release form. This is sort of the standard around all of the United States in general and all medical facilities. So you are probably familiar with HIPAA, and the HIPAA is the Health Insurance Portability and Accountability Act, and it was passed in 1996 to preserve and protect the privacy and confidentiality of healthcare information. So as you also know by now, patient confidentiality is extremely important, and not following guidelines can be detrimental. So an example I have of this is a few years ago in the healthcare system I worked for in Oregon, we had an employee access 2,500 patient records between October 2014 to January 2017. And this was without authorization. She had no reason to look into any of those charts. She admitted to viewing the files due to curiosity, according to officials. All of the patients whose records were accessed by her were notified of the security breach, but Oregon state law requires that the Attorney General be contacted if more than 250 individuals need to be notified of a security breach. So she was terminated. The incident was also reported to the Department of Health and Human Services Office for Civil Rights and state regulators. And then the county district attorney launched an investigation into the incident to determine if any criminal laws were violated. I did not hear about any criminal laws that were brought to her due to this incident, but it's just a good example of why confidentiality is so important and what the consequences could be for breaching that confidentiality. Now, social networking is something that is probably very familiar with everyone. It has caused an increase in violations of confidentiality, and it's typically done without intent, but we do need to be aware of institutional policies. Um, you know, a lot of times it's immediate termination if it's found, and then you could also have cancellation of contracts or affiliation agreements with outside agencies. So there's several consequences that can be involved with violations with social networking. There's Facebook, Instagram, Twitter, Snapchat. I'm sure I'm missing more than those four. But looking into social networking on page 41, there's a great example of how not following confidentiality regulations while using social networking can be detrimental for your career. So it details how a patient's names from an ED board or computer, so they were clearly visible on a computer in the background of a selfie picture taken by a student who posted that photo to her social networking account. So I guess at the time, staff were celebrating a physician's birthday, and then she took a selfie in the ER. So the nursing student, I guess it was reported by another staff member who saw that on her Facebook account or her social networking account. And then they brought that to the higher ups there in the hospital system. So that nursing student ended up losing her scholarship. She had to pay back all of the scholarship funding that had been provided to her up to that point. And then she also was identified as a do not hire within the organization. I don't believe anything happened with the physician because he was unaware of what happened. He didn't see the social networking account that student had. So, but it's very detrimental for her in this case. So it's a good example to be mindful of what you're posting on social networking. And a lot of times employers do tend to follow up employees on social networking to see what they're posting. Okay, slander and libel. So they're both categories as quasi-intentional torts. Slander refers to the spoken word. So an example of slander is if a nurse makes a false verbal statement about a client's condition that may result in injury. Another example of a slanderous statement is a patient getting labs done for drug testing and verbally stating they have a substance abuse problem when that is not the patient's reason for the drug testing. And libel refers to the written word. So a libel example from your book mentions nurses who had written a complaint about a coworker who they were having difficulty with. They sent a written statement to the CEO of the hospital embellishing some of the incidents that occurred, and then took statements made by coworkers out of context. So they changed the meaning of the remarks, which seems harmless, but in fact, in this case, it made damages to this person's credibility personally and professionally because she was reprimanded by the CEO. Then the employee ended up suing the staff who wrote the statements for libel and slander. So one good thing to consider is that always please take a moment to think before you speak and write. It's just a general advice for nursing staff. Okay, false imprisonment is confining an individual against his or her will. So restraining is physical, detaining is verbal. So false imprisonment related to healthcare can include confining an individual against his or her will. And hint, hint, you might want to know what false imprisonment, the definition is. Examples include detaining an unwilling client in an institution when they want to leave, removing patients' clothes from their room so they cannot get dressed to leave, keeping a patient who has been medically discharged for an unreasonable amount of time, or using restraints on individuals without the appropriate written consents or following protocols. An example of this is Mr. Harvey on page 42 of your book. And Mr. Harvey is an 87-year-old man who was admitted from home to the ED with severe lower abdominal pain and vomiting for 3 days. He's a very active, independent elderly gentleman who lived at home with his wife without needing any additional help. He was diagnosed with a ruptured appendix. He had surgery, eventually was transferred to the surgical floor, awake, alert-oriented, and in stable condition. Later that night, he became confused, irritable, and anxious, attempting to climb out of bed and pulling out his Foley. The nurse restrained him. The next day, his confusion continued. The nurse placed him in a chair, restraining his hands. When his wife came 3 hours later, she found him in the chair unresponsive, and he died of cardiopulmonary arrest. Then the wife filed a wrongful death lawsuit and false imprisonment against the nurse manager, the nurses caring for Mr. Harvey, and the hospital. They ended up finding out the primary cause of his behavior was determined to be hypoxemia. So in this example, it's a good reminder to critically think and try to understand and identify the underlying causes for confusion, irritability, and anxiety that often can be present when there are other metabolic causes needing correction. So you almost have to be like a detective in some of these cases. Assault and battery. So assault is a threat to do harm. Battery is touching without consent. The significance of an assault depends on the threat. So one example of battery in the medical field includes procedures without informed consent. There are exceptions for emergency situations, which then that's called implied consent, and we'll go into that in a little bit. In that case, the standards of care will drive the deciding factor as to whether or not the procedure was necessary without obtaining informed consent. So an example of this also in nursing practice includes a nurse who tells a patient, if you don't stop pushing the call bell, I'll give you this injection with the biggest needle I can find. This is an assaultive statement. Battery would be if the nurse gave the injection after it was refused, even if the medical personnel deemed it was for the client's good. So with few exceptions, patients do have the right to refuse treatment. There's always the AMA patients or against medical advice, so they do have the option to, again, refuse treatment. But I would say majority of the time you can prevent AMA patients by providing plenty of communication between the patient, the physician, and yourself. Moving on, we're going to start looking into standards of practice. So for standards of practice, nursing standards were established and guidelines for the profession to ensure that we provide an acceptable level and quality of care. The Nurse Practice Act defines the boundaries of nursing practice within individual states. So it's the scope of practice, what you can do as a registered nurse. Standards of practice include how well you should provide care while utilizing guidelines to ensure quality of care. So state boards of nursing and professional organizations develop these standards, and then they delineate responsibilities. In practice, it typically entails defining the minimum acceptable level of care. Nurses are judged on generally accepted standards of practice for their level of education, experience, position, and specialty area. So courts typically look to the boards of nursing to regulate standards of practice. And how boards are able to do this is through direct or delegated statutory language. So this is where the ANA comes into play. So we can use the ANA guidelines to help us clarify our roles at varying practice levels. Looking into varying practice levels for standards of practice include utilizing guidelines from specialty-directed organizations such as the AACN, which is the American Association of Critical Care Nurses, or we have the AWHONN, the Association of Women's Health Obstetrics and Neonatal Nurses. So it's a good idea to review on Moodle. There's Virginia laws, Virginia regulations, the Virginia scope of practice, and then ANA standards of practice. So please review those. All right, internal standards. So internal standards are developed within the institution itself. It's usually explained within specific policies. Just know it is your responsibility to understand, know, and meet the institution standards. And then this is why it is so important that institutions should communicate any changes. You'll find that especially with Riverside that it's constant emails about changes that are happening, changes with policies, new procedures, new ways of doing things. So they try to base everything on current literature and research. But again, it's our responsibility to understand how the hospital system wants you to do things, and it's all quality based nursing practice. Okay, use of standards and nursing negligence and malpractice. So how does that play? How do standards in nursing work into figuring out if something's negligent or is related to malpractice? So we have our standards of practice, and they're usually determined in a way that, was the action prudent? Was it not reasonable? Et cetera. They're looking at what is the standard? How does everybody perform this action? And, was it prudent? Was it based on what others in the profession would do or follow? Professional standards can also be utilized, including state, local, national, or specialty standards. They'll also look into the institutional policies. They'll even gather expert opinions. They'll look at research and evidence-based practice if needed or warranted. So there are multiple areas to look into when seeing if an action was negligent or if it's considered malpractice. Okay, Patient's Bill of Rights. So this is just a real quick slide. They're created by the American Hospital Association in 1973, amended again in 1992. Typically, at the hospital, you might see posters of Patient's Bill of Rights down in the ED when they walk in. Sometimes hospitals will give handouts every time when they come and register for, surgeries, or they come into the ED. Really, it's just something that patients need to know that they have rights as well while they're a patient in the hospital. In 2003, though, it was replaced by the Patient Care Partnership, and then essentially patient rights were derived from the ethical principle of autonomy. Okay, so I told you we'd get back to informed consent. So informed consent requires physicians to divulge the benefits, risks, and alternatives to treatment, non-treatment, and or procedures. It's a legal document in all 50 states. It requires, again, the physicians to discuss what are the benefits of this procedure, what are the risks, Are there any alternative treatments to what we're doing? What would happen if I didn't get treatment? And then, are there any other procedures that can be done to fix what's going on with me? So it also allows patients, family members, and individuals to kind of be involved in choices about their health care. It includes that very important communication piece between the physician and the patient. It also permits healthcare providers to touch. They need to talk to their patients. They need to discuss the important issue of what the benefits and risks are. Physicians are responsible for obtaining the informed consent. And how were we involved in this process, really? So we technically are the ones that witness the signature, but we're also there for clarifying questions. So, have them restate what they just heard to ensure they understand what the doctor said. And then if it comes down to it, and if we feel that a patient lacks a full understanding of the risks or benefits, then we are the ones that should notify the physician. And you might get a little pushback from them, and they might say, like, well, I was just in there, I talked to them. But then you need to start advocating for your patient and say, listen, they don't understand this or that about the procedure. You need to come back and talk to them. I will not witness this consent until that's done. So again, advocate for your patients in this case. All right, so criteria for informed consent. So a mentally competent adult as voluntarily giving the consent. The client understands exactly what he or she is consenting to. So the nurse should have the client restate exactly what they're consenting to. The consent includes risks involved in the procedure, alternative treatments, and risk of refusal. Consent is written. So we talked a little bit about implied consent. Um, that occurs when consent is assumed. There's emergency situations, whether a child's involved, and then the healthcare institution's unable to reach parents or legal guardians. Typically, on procedure consent form, there is a section for the physician to sign in case it's an emergency situation, and neither the patient can sign or no one's available to sign for them. In the case of a minor, typically it's the parent or guardian that needs to give consent for the treatment. And then if it is an emergency situation, no one's there to sign, then it's implied consent. So another avenue to look into is, well, what if I have a patient who's cognitively impaired, they have dementia, Alzheimer's, they're unresponsive, like what do you do in that case where they're not able to answer for themselves and you cannot get a hold of family or family's not there? So in that case, you really have to wait until because if it's an emergency situation, then we have implied consent. But if it's a non-emergency situation, then you need to really get informed consent. So what we would do in the hospital I worked at is that we would try to contact either a spouse, a family member, a parent, designated healthcare decision maker, somebody who we could get in contact with to get the permission over the phone. Um, so I've had situations where, again, no one's in the hospital to sign for them. So I would call whoever it is that we would designate and then received informed consent over the phone. And then at that time, if they had further questions about what the procedure was, risks and benefits, um, this person too, it's also the physician needs to speak with them. So a lot of the times when I would talk with them over the phone, one of the first questions I would ask is, has the physician talked to you about the procedure? Have they called you? Do you agree with the procedure, risks and benefits, and consent? And then if that was the case and they agreed to it, then we could get another nurse to witness that signature. So, in the case if it's like a physician who signed the consent and then we're trying to witness it, then we can witness it with another RN over that phone call. So I would speak with say it's a spouse, I would speak with the spouse, get consent, and then I would pass the phone over to another nurse, and then they consent, and then we would be dual witnesses for the phone consent. So, just in case that ends up happening to you, kind of have an idea of what you would need to do. Okay, so staying out of court. So if you look at box 3.1, Page 46, there's a list of avoiding legal problems. So unfortunately, the public trust in the medical profession has declined over recent years. It's about perception. Do patients and families perceive that behaviors are uncaring, attitudes are impersonal? If that's the case, then they're more likely to sue. It depends on what their view is. I mean, to them, seeing somebody who is uncaring and impersonal might, you know, they might view it as somebody who might make errors in treatment. Now, if a patient feels cared for lovingly, a relationship's developed, then you're demonstrating care and concern, making clients and their families aware of choices and methods. This can help decrease that liability. So, involving the patient and family in decisions about their care helps in this case. And then, if patients and families perceive that you care for them, you're concerned about them, it can reduce the likelihood of a lawsuit. So, prevention, staying out of court, practice caring behaviors, demonstrate an interest in patients and their families, assist patients and families in making choices by providing information, keeping that communication open, maintain accountability, and then make sure to adhere to standards of practice. You can also see table 3.1, page 46, common causes of negligence. All right, documentation. This is super important. So if it's not documented, it was not done. Do not just chart by exception. It's very important that you chart progress. I mean, that can be even in the form of a care plan. You want to make sure that it's legally credible. So what does legally credible mean? You want to be clear, concise, state the facts. You want to be accurate. You want to chart how it was done. You want to chart truthfully and honest. Remember to only use approved abbreviations, document at the time care was provided. If you need to, say you're back the next day on your shift and you forgot something important to chart, you can type in late entry. Keep documentation objective and factual. You can use quotations from patients or visitors if needed to explain a situation. I mean, I've had to do that, especially with in times of stress and, I get an angry family member, angry patient, and they start cursing at you. Yeah, I'm going to chart that because I think it's important for that to be documented. That can technically be some sort of verbal abuse towards you. It's a situation that should be documented. Um, Also, make sure it's appropriate. So document only what could be discussed comfortably in a public setting. Always use a barcode scanning process on both your clients and medications, and then try to avoid any shortcuts in documentation. And the best thing to do with assessments is try to, I know it can be challenging with time management, but make sure to document the assessments after completion. I think that was the main reason why they ended up putting computers in patients' rooms, was to keep you at the bedside longer and also give you the opportunity to chart while you are completing tasks. So, once you get out there, you'll kind of do your thing and you'll figure out how you're going to work your day through, when you'll do your assessments, when you'll do your charting. But it's just a good suggestion to try to get those done as soon as you complete your assessments. Okay, so common actions leading to malpractice suits. There's obviously failure to assess properly, failure to report changes in their condition to the appropriate personnel, so failure to document in their chart, altering or falsifying a record, failing to obtain informed consent, failing to report a coworker's negligence or poor practice, failure to provide appropriate patient education, violation of internal or external standards of practice. So if you look at the case on page 47 of Tovar versus Methodist Healthcare, it details the 75-year-old female who came to the ER who had reports of headaches and weakness in her right arm. Although the physician wrote an order for admission to the neuro care unit, 3 hours passed before the patient was even transferred. After the patient was admitted to the unit, nurses called the physician regarding the client's status. However, it took 90 minutes for another physician to return the call. 3 hours after that, the nurses called to report a change in the patient's neurostatus. And then a STAT CT scan was ordered, which revealed a massive brain hemorrhage. The courts established the following based on the standard of care. So, nursing personnel provided poor documentation of the clinical status of Ms. Rodriguez between 5 p.m. and 9 p.m. Despite the patient's obvious deterioration of time, they meekly accepted inadequate responses of the physicians with no further calls to them until 12:30 in the morning when the patient was in distress. So the appropriate standard of care for nursing personnel treating a patient with acute neurological process is to promptly, expeditiously transfer the patient to the appropriate setting and carefully inform the treating physicians of any changes in their clinical status so that the appropriate care can be rendered. So the nursing personnel in this case failed to perform those critical functions in their management of the patient, thereby breaching the standards of care. Okay, so what to do if you're named in a lawsuit? Most institutions have lawyers to defend themselves and their employees. I mean, you want to make sure that you contact the legal department of your institution, make sure you answer the complaint. If you do carry malpractice insurance, notify them immediately. Never sign documents without consulting the malpractice insurance carrier or legal representative. Um, Maintain a file of everything that is connected to the case, and then you always want to be honest. Concealing information usually causes more damage for you. So there are many options out there for professional liability insurance. I think you really need to consider obtaining insurance. It's important because, look at the hospitals and what their highest priority is when it comes to liability. So they will protect themselves before they'll protect you. It's a general sense that I see. So liability insurance is something that is a great addition to you. It's a good security. Um, you know, it typically runs about $100 a year, so it's very affordable. Typically, if I had you in class for this, I would show you what I use for professional liability insurance and then what the coverage is. So, unfortunately, we can't do this with the online lecture, but just know, you might need to end up hiring a personal attorney who is experienced in malpractice law. You can feel at times that you're not adequately protected or represented by the attorneys from the hospital. So the better option just in general is to have professional liability insurance beforehand. So another thing to mention too is that even if it's a frivolous suit and the patient fails to incur damages, you will still face expenses. All right. End of life decisions and the law. So you have your DNR, do not resuscitate orders. So they're a specific directive to healthcare personnel not to initiate CPR measures. Only a physician can write or enter a DNR order. So this usually occurs, after they consult with the patient or family members. Make sure they have a clear understanding of what a DNR means. It does not mean do not treat. So that is something that is a myth. Advanced directives too. So in 1990, there's the Patient Self-Determination Act that was created, and really it was created to address questions regarding life-sustaining treatment. So, and it also keeps the family from having to make decisions for the patient at the last minute. Be sure to look into box 3.2, page 49, the nurse's role in DNR orders. It's very informative. So, the other thing is a living will, and this also is a form of an advanced directive. It essentially is leaving instructions for treatment too. A legally executed document that states the individual's wishes regarding the use of life-prolonging medical treatment in the event that he or she is no longer competent to make informed treatment decisions on their behalf and is suffering from a terminal condition. So, what's a terminal condition? It is considered, to a reasonable degree of medical certainty, there is little likelihood of recovery or the condition is expected to cause death. Terminal could also refer to a persistent vegetative state characterized by a permanent, irreversible condition of unconsciousness in which there is absence of voluntary action or cognitive behavior of any kind and an inability to communicate or interact purposefully with the environment. Also, there's the healthcare surrogate, which is known as the durable power of attorney, for healthcare, durable power of attorney. This person is someone who has been authorized to make decisions on the patient's behalf when they're incapacitated. So, to make the patient's wishes known, essentially, to medical or nursing personnel. They are chosen by the patient, and it's usually a family member or close friend. Typically, the durable power of attorney will have paperwork and documentation that they can provide to you to prove that. Okay, so we talked a little bit about this in the previous slide, Patient Self-Determination Act. So this act was created in 1990, again made by 2 senators to address questions regarding life-sustaining treatment. It does allow people to have the opportunity to make decisions about what treatments they would want, especially if they're unable to choose for themselves ahead of time. So it spares family members from having to take this burden, in the moment. And then federal law directs the healthcare institution to receive federal funding, inform all of their patients of their rights to create advance directives. So that's why typically you'll see like ED registration, or if you're going for a procedure, they'll ask you, do you have an advance directive? And if not, then they'll be like, do you want information about it? And then you can decline. So provisions of the Act, it does provide information to every patient. All patients must be asked if they have a living will. Um, they will ask about a healthcare surrogate, durable power of attorney. The healthcare surrogate is who makes the client's wishes known to all healthcare personnel. Must be placed in the patient's record, and then educate your patients and their families on the provisions of this Act. Be respectful of patients' rights, and then again have cultural humility and be aware of how different cultures might, I guess, consider how this conversation would be. Um, that's essentially it for this slide. Let me keep moving on here. So, nursing implications in regards to this Patient Self-Determination Act. We are advocates for our patients, so it's good for you to have some knowledge of advance directives. So when patients ask you questions, you can help them answer them, or if anything, help guide them to resources available to answer questions about it. Um, Definitely review your institution's policy with resources. When I worked in Oregon, we had our chaplains who were specially trained to talk about advanced directives, the DNR process, and especially with like hospice and end of life care patients, they would always be involved for them. Okay, some issues affecting practice. So, accepting and rejecting work assignments can be a real big issue, and I can't imagine what it's like today with coronavirus happening. But make sure to read Appendix 2. It's page 287 to 292. It does list some good information about what to do with work assignments. The main thing is you really want to communicate your concerns ahead of time, mainly until somebody listens to you, and then consider the chain of command if needed. So you talk to your charge nurse before you accept your patient assignment and say, this is unsafe, I cannot accept it. If the charge nurse doesn't respond to you, then you move up to the manager, and so on. So this happens quite a bit too when you're floated to another department, or if you're asked to receive an assignment that's considered unsafe to perform independently. You have the right and obligation to request and receive a modified assignment. There are legal implications of mandatory overtime that you need to consider when asked to stay over for your shift. Typically it's voluntary. If there is mandatory overtime, though, you do need to consider a few things and how you feel. How will it affect patient safety? Look at the position statements from nursing organizations on mandatory overtime. Look at the Nurse Practice Acts and how that involves mandatory overtime. I have to say, majority of when I was in the hospital system, I think I only came across that maybe once out of 13 years. So it's pretty rare that it happens. And I worked for, in Oregon, the hospital system I worked for had a union. So we had, the contract to help guide us with mandatory overtime, which wasn't allowed. We never had mandatory overtime. And then if we did want to stay over and volunteered for it, we would get incentive pay. Okay. Licensure. So we're almost there. For licensure, we know that there's specific criteria that needs to be met in order to meet qualifications. The NCLEX test is prepared and administered through a testing company. It's called Pearson Professional Testing of Minnesota. Qualifications include graduation from an approved nursing program with a minimum of 500 hours of direct patient care. You're being supervised by a qualified faculty member. Endorsement is when you're licensed in one state and then you may obtain a license in another state by endorsement. So this happened when I moved from Oregon to Virginia. I applied for a license by endorsement, and then it's granted based on rules and regulations of the state. Although some states vary with CEUs, there are other legal requirements and other educational requirements too, but typically the licensing agency that you work for, so Oregon State, provided all of the information that Virginia needed in regards to CEUs and educational requirements. It's just best to contact the state and find out the exact requirements for licensure if you're having any issues with licensing by endorsement. There's also multi-state licensing, which is now referred to the Nurse License Compact. Not all states belong to it, but there are several that do. And the states that belong to a compact have passed legislation adopting terms of this agreement and are known as party states. So if you go to, it's https://www.ncsbn.org/nlc.htm. That'll give you a little bit more information about the Nurse Licensure Compact Act. It does only apply to the basic RN license, not advanced practice. And you have to have a home state where the original license was issued. And you must renew your license in a home state. I think this is a good time to, I'm going to take a break here and cut off the recording, and then I'll start up the second session of this recording. So please look for that in Moodle. Thank you.